Sorry about that.
He's given a copy and we had a brief discussion about it before the hearing.
And so the statute allows it to be admitted, the evidence for purposes of the hearing, assuming there's no objection to that. No objection.
No objection, no.
So of course, read it.
That's just
Admitted.
Counterclaim of evidence that can't be produced.
Conclusion that Mr. Norton is not competent.
Maybe Darrell would like to address the court. You and I had a prior conversation in which the state was informed that I would not be being a witness. It is now a witness.
Sir, in my previous discussion with Attorney O'Neill involved a stipulation to the incompetence finding and agreeing with the report as reviewed by Dr. Young. In having a conversation with Mr. Norton prior to this hearing, before coming in here, it's clear that we do not want to stipulate at this point to the finding of incompetence. Obviously, we've reviewed the report and gone through that, but at this point, we're not prepared to. We don't have any evidence to offer in contradiction of what's being presented in the report.
Actually, that's not true. She was dropped off information pertaining to this case in which she failed to contact her client. I don't have a problem with incompetency. I have a problem with my attorney being able to inform the courts of the information she's in turn applied. Because I don't have a problem with incompetency. I have a problem with my lawyer being able to represent his client in this particular case.
While I can't understand much of what we talked today, it seems that the basis for this motion is that you object to Ms. Ma representing you because she's employed by the state.
She's employed by the state and hasn't. She has.
And that's not a basis to replace assigned counsel, public defenders, because they're all paid by the state. And it doesn't mean that they're not, by that alone, not representing their client, but also under their own ethical requirements. So if you want to hire a counsel to pay for yourself, you're free to do that, but we're not going to replace this.
Well, the state's currently in, still has possession of my personal property that was seized. Well, you're financially extorting me by holding assets illegally. There was no probable cause to actually withhold my assets.
So the motion's denied. So is there a stipulation to incompetency or not?
Actually, I'm not incompetent. The only thing I have problems doing is getting my lawyer to recommunicate effectively what she's been presented. She's been given witness statements that disagree with the findings of officers and of the state. They also apply against her.
The merits of the state's ability to prove their case has nothing to do with whether or not you're competent to stand trial. That's the only question today. Clarity on is whether or not there's agreement to Dr. Young's report and findings and conclusion that you are not competent to stand trial. And all the reasons. That's all the court wants to know today.
I think I'm perfectly competent. However, with all due respect, I'm wondering how counsel is going to represent information that negatively reflects her personally through other witness statements that she's been given.
Keep going off on a different direction. So, does the defense want to come in to hire his own expert to dispute Dr. Young's conclusion?
I would like to hear what her plans of representation are.
I'm talking as well right now. Time to hire another evaluator? You already had Dr. Linder who concluded that.
Right, we already did have the evaluation with Dr. Linder. It appears that Dr. Young's report concurs with those findings. I don't believe we would want additional time to hire an additional expert. We would most likely go back to the expert that's already been employed in this case, and it doesn't change the findings. I think for purposes of today's hearing, Mr. Norton's incredibly clear in wanting a not stipulation to the finding of incompetence for the report, and reviewed it and had a chance to look at it. I don't have any evidence to put on to the contrary as far as the hearing today is concerned.
With all due respect, my lawyer contacted me and said the original psychiatrist she hired actually changed his opinion. After the fact, I've already received a fraudulent deprivation of rights. Now, I'd like her to clarify what that actually was. It's recorded if necessary.
Are you recording today as well?
I recorded this on a previous voicemail that's still saved on the phone.
Again today.
Yes, I was.
I told you this before, so I gave it to the court, I'll give it to the court officer. I'll go through the all from you on site, is she recording too?
No.
We're not gonna do this every time we're here.
Oh, with all due respect.
No, there is no respect right now. The court was clear last time that you don't record, because we are recording this, that is the official recording, and you did it again anyway.
Well, I have not received records from my attorney. I've requested
You
them.
got it from the court, and that's all you need it from.
I haven't received
You
official
got it from
records.
this courtroom.
Yes, ma'am.
So, do you wanna respond, Miles, to this?
Per my memory, I haven't had any communications with Dr. Linder that would reflect that statement.
I'm not sure of what the evaluation is since I've requested it and it hasn't been turned over.
Ms. Miles said she gave you a copy.
I can play the voicemail for the court if it would like.
Ms. Reinhardt, you seen the report from Dr. Young's recently?
I received this today, and I just looked at the conclusions, and from what I could see while I was sitting in on the evaluation, I tend to agree with those conclusions that we
Just for the court, Mr. Norton has another recording device.
No, this was actually the voicemail in which Amanda called me confirming that her report was rather inaccurate. She's also orally confessed that she would stipulate that to the court. She's fraudulently representing her client intentionally, or supplying information that is rather inaccurate to her client. Would the court like to hear the voicemail? It relates to her original opinion. I'm not recalling the exact date, I'd have to research that. However, it was prior to the evaluation with the Dr. Young. Prior to the last one. It'll take me a minute to get to it, but I can play it for the court if it will please the court.
I don't know what the recording says. I don't know when it's from. If I leave that up to the court.
Okay, it'll take me a couple minutes. It's one saved for a while.
One. First saved voice message. Hey Josh, it's Karen from the Public Defender's Office. Just wanted this message will be saved for 21 days. Next message. This message will be saved for 21 days. Next message. This message will be saved for 21 days. Next message. Hi Josh, this message will be saved for 21 days. Next message. Hi Josh, this message will be saved for 21 days. Next message. Hi Mr. Norton. This message will be saved for 21 days. Next message. Hi Josh, this message will be saved for 21 days. Next message. Hi Mr. Norton. This message will be saved for 21 days. Next message. You're with the Rutland Public Defender's Office. I'm calling it's around 10:15 Tuesday morning. Calling in regards to the evaluation scheduled at court for Thursday at noon. It's scheduled with Dr. Linder. If you remember, Dr. Linder was our expert and had done a previous evaluation. I've gotten in touch with him, and I think it may be an issue for him to do the court-ordered evaluation. My reasoning being, if for some reason he had a different opinion this time, we may be in a position where we are cross-examining our own expert. I wanted to know if you had any input on him doing the court-ordered evaluation on Thursday or not. We'll also get in touch with Rita. I'll be in and out of the office today. If you don't get me, leave me a message, but I should be here until at least 10 right now, and then midday, and then the afternoon. Thank you, Josh. Number here, 786-5823. This message will be
She's asking if you want to have him review or supplement his prior report to his evaluation.
She said he had a different opinion this time.
If he had a different opinion this time, if was in there.
No, she stipulated that.
You're not just
Well,
But this has to do with when the court specified that Dr. Linder would do the report. And I think that was in reference to when Dr. Linder was court-ordered to do the evaluation, when I believe we had then reconvened and discussed that it was Dr. Young to redo that report. So I just tried to clarify that with him as well.
Linder was the defense
Expert, correct.
And also from what I remember having conversations with Ms. Melch, and it seems from that message, that she was trying to actually do the best thing for her client, which was to have a reevaluation, that she was advocating for Dr. Linder to do it again, hoping that he were definitely in there, that she made no promises. I think it's almost clear that defendants listening to me do the same thing, or recording something that his contact with defense attorney only shows that what he chooses to hear and what everybody else is hearing is completely different. I don't know if it's a safe place, but I think Ms. Mal has done an extraordinarily good job as an advocate for Mr. Norton in all my dealings, whatever bearing that has on the court.
So, this matter was set for conference again. Dr. Young had filed his report with the court on November 19th. It's been ample time to review that and seek a request prior to the day and obtain an independent evaluation to see if there's any contrary opinion. It's been the opinion of both defense expert and that the court's court-ordered evaluators that Mr. Norton is not competent to stand trial. There's been no difference in that opinion from either of the experts provided to the court to date. Young in the court indicated that the report has also read Dr. Linder's prior report, and Dr. Young's recent report, which is admitted as evidence, indicates that his opinion that Mr. Norton suffers from a condition best characterized as delusional disorder, which is a psychiatric condition, specifically a psychotic disorder characterized by non-bizarre delusions. His symptoms represent the early symptoms of schizophrenia or similar psychotic disorder. Individuals suffering from delusional disorder, in contrast to persons with schizophrenia, generally are able to function effectively in most aspects of their life. It's based on that opinion in his evaluation with Mr. Norton here in the courthouse the last time, because we had to arrange it to make sure Mr. Norton would attend and participate according to the rules that we evaluate are not Mr. Norton's preconditions. Dr. Young determined that Mr. Norton is not competent to stand trial in the court so finds, because he's not able to, with mental illness, demonstrate abilities usually considered by the court in finding the defendant competent to stand trial. He's unable to demonstrate sufficiently rational understanding of proceedings, involved with, or work effectively with an attorney who might be effective defense. And further, he continues to have paranoid ideation about the police, about flight, his own attorney and the judge, continues to have marked perseveration and inflexibility in his thinking about interactions with each person and his thinking about the legal process. Qualities clearly apparent in Dr. Young's interview with him. The court will find and conclude that Mr. Norton is not competent to stand trial in any of these pending cases, except the matter for hospitalization hearing. The state is to confer with the Department of Mental Health, and whoever's going to do it needs to be ready to do it.
We will do whatever, we've had multiple conversations with Dr. Young. I have contacted Rutland Mental Health back when we had an original plan, which was like a while ago, but I don't think they were prepared to deal with the situation as it evolved. But I'll be more than happy to do that. Thank you.
I have a hearing that looks like we're going to be doing that at 10:30 on January 23rd, 2014. Now, January 23rd.
Okay. The only problem that I have who, when I contacted him for this hearing, explained to me that he has a huge backlog of patients, and he might need some time, even if he could make it, to rearrange. Is it possible to have a little bit more time than that?
File a motion to continue with his
Do that then. I'm going to set it January 23rd, 14 to 10:30, and it's set for 1 hour. And I'm going to print the hearing notice so you can get it done.
Okay, thank you.
You're welcome.
Come on.
No. Thank you. I'm
So,
tired of saying that.
prior to the next hearing, if I can implore you on any level to just go to Rutland Mental Health, set up an intake, go through the motions, whatever you can do there, because if we can head off.
Amanda, why would
bear
I
with
waste
me.
my hard-earned money
Because if
on
we can
something
show
that only needs
effort,
to be
if we
resolved
can-
on your behalf?
If we can show that effort and show that either services are applicable or not applicable, but you've done that and made the effort and done what would happen under an order of non-hospitalization, perhaps we can move forward quicker with trying to have these all dismissed. Or at that point, my filing a motion to dismiss in the interest of justice with that information attached. If you can set up calls, if they're able to fit you in before then, that would be something that could at least move this along perhaps a little bit quicker and get us to an end result of dismissal a little bit quicker, hopefully at all. I mean, that's the main,
So you
that's
still
my
have an
main goal
injure
at
an
this
officer
point.
case.
Pardon?
So you still have an injure an officer case,
So I don't have any injure of an officer case, I just have the criminal cases, which are the
which
three
involves an
pending.
injure an officer
And
that
right now,
you
we're
cannot
in-
represent. You've expressed fairly adequately that you're
Right,
not.
I can't do any civil cases, Josh.
It's not civil. It's actually evidence that would dispute the accuracy of evidence.
If, I mean, for purposes of today and moving on for the next hearing, if you could contact, and I mean, I know previously there was an issue with signing releases or not, but if they could just communicate to me whether you went or not, or if you could get something signed saying you did or didn't, a confirmation of that, it's going to show a lot, at least to this judge, because I don't want to be in a situation where this then gets worse in any sort of mental health realm. But if we can do this proactively, perhaps ahead of time,
We can
then it
work on
alleviates.
something else.
Yeah, we can work on something else and say the state is going down this path that there's really no validity to doing, and we're going to do that regardless. But
There
if
is
we
no
can-
validity to alleging mental health in a conflict case
Unfortunately, at this point, we do have the finding of incompetency, so the next hearing
on
is
by a state employee
hospitalization
hired
hearing.
by a state employee
It's
in a
your
state conflict
choice.
case.
If there's an order ordering you to go to Rutland Mental Health, I'd rather us deal with this up front and try and deal with it ahead of time, where we can say, Josh is gone, he thinks this is foolish, he's not in agreement with it, but he went, he's doing what the court is gonna order him to do at this point, and there's no purpose to it. They can't either offer this as services, or you've already done it and exhausted those. And that's just my pitch. I mean, that's what it
If
is.
you've already done it, they can't order you to do it.
Precisely.
So therefore, that's already accomplished.
And it stops this cycle of having to, or gives me even more of an argument to stop this cycle of having us to keep coming back and deal with these
Why do
same
we
issues.
have to keep doing this?
Right.
So you gotta waste my insurance money on something I don't want or really need.
If we're in a position where the judge enters an order of non-hospitalization against you to have you do that,
Then she will intentionally waste my insurance money.
if we can show this ahead of time and either it's helpful, it's not helpful, and we don't have to use it if we come to the hearing. I mean, we don't have to. That'll be a discussion that the three of us will have again. But in trying to proactively head this off at the pass, that would be my recommendation of a way that we could bring this back into control. That's just what this is.
Yeah.
Okay. So, initially my question is going to be,
I'm sitting already.
I provided a copy of the report to Rita, you have a copy of the report. It's up to you whether we decide to stipulate or agree to incompetence or not.
I'm wondering what you're actually planning on doing with the case. You haven't done a thing with your case.
So my question just pertained to this hearing.
Amanda,
which
there
the
is no
competency
incompetency
here.
issue. There never has been. I'm
So
wondering how you
unfortunately, we're in
plan.
a place where the judge is gonna ask me whether we stipulate or don't stipulate.
Amanda, how do you plan on actually presenting your case on information you've been
Without an
presented?
answer to that question, then I'm
There
gonna-
is no incompetency issue.
Okay. And that's, I need to hear from you what you
There's
want
a
me to do.
complete failure on your half to go over information you've been presented, but there's no incompetency issue.
Josh, it's the word that we're trying to get to, okay?
That's the important thing. It's the word. And it has nothing to do with the dictionary meaning of the word. All right? Are you, I don't know if you're...
I'm fully capable of rationalizing the situation here.
Josh, I know you better than that, okay? How many years have I known you? For God's sakes, I know that. But we've got to get past the dictionary definition. And we've got to get
past the fact, is she able to actually deal with her case?
Leave her out of this until we get to this meaning of the word, okay? Because that's the whole thing right there. It's the legal definition of what the word means. And that's what we have to work on right now. The legal definition of the word incompetent has nothing to do with the dictionary definition.
The legal wording of incompetency in state law is the ability to communicate with your lawyer. We have that problem because I cannot communicate with my lawyer directly on how she plans on representing her case with the facts she's been presented. It's not my problem communicating, it's her problem communicating with her client. She's been given ample time to address the case, what she's completely failed to do.
Okay.
We spent 0 time from the time of the evaluation up until now. She called me around 4 o'clock yesterday. That's not adequate representation. And her office was actually given information into the case.
Okay. Okay. Now, we still need to get, what the judge is going to be working on is the word right now. Okay? And that's what she's trying to get you to understand about this thing,
Yeah.
the evaluation.
Actually, there's several errors in that report.
Well, I mean,
Well, if I'm incompetent, it's hard to imagine that someone that's highly competent could have a report full of errors.
But I mean, that's what we're going to have to work with today. Okay? And that's what she's trying to get at right at this moment.
So what actually is your plan?
So my plan previously was to stipulate to the finding of the report by Dr. Young, which was incompetence. This is, I mean, ultimately, this is a discussion that you and I can have, is whether you're willing to do that or not. If you're not, we don't have to agree with that.
What do you plan on doing with any information if we actually go forward with the case?
So
That's
right
my problem
now,
with you right now.
The fact of the case is the underlying fact of the case, as has been explained by the judge, myself, Rita, numerous times, is that's at a standstill. Right now, we're in this
So you're
realm.
stalling out your cases, basically.
We're in a realm of the mental health field. We're dealing with the competency hearing. I need to,
I hit it.
we need to know today if you want me to either agree to the incompetence finding or not agree.
I want you to disagree, and I want a lawyer that's actually capable of representing the
Let's
cases.
go in because they're calling it a hearing, and I can discuss with that, okay? Well, okay, you can come in.
The judge is going.
I'm a defense attorney. My job is
Amanda, you are a state employee.
prosecuting you.
Well, actually, you don't do that by putting in a fraudulent report on your own client.